Everybody. Thank you all for coming out today for this conversation on civil asset forfeiture. It's sure to be productive. Just one item of business I'd like to note is that this Friday, the 12th of December, we are actually having another, two panels actually, in Harris County at the Harris County Justice Summit. Details and information registration are available online. That, much like this, is free of charge. I would like to see anybody that can make it out there learn what we can do to apply some of the principles that we discuss in our Center for Effective Justice, also in Harris County as well. So, without further ado, civil asset forfeiture, an unfair exercise in forum shopping, a sustained assault on Fifth Amendment due process, policing for profit. Conversely, picking up the torch dropped by budget authorities interested in playing politics, an indispensable tool for combating increasingly sophisticated criminals. These terms have been used in the academic and popular press about civil asset forfeiture, the very phenomenon that we're here to discuss today. My name is Derek Cohen, and I'm the policy analyst for the Center for Effective Justice at the Texas Public Policy Foundation and in our Right on Crime campaign national. I'll be your moderator today. Just one quick item of housekeeping. If you'll notice on the original invite, Chief James McLaughlin from the Texas Police Chiefs Association was originally scheduled to join us today. Unfortunately, he had a personal incident come up, and pinch hitting for him is Shannon Edmonds. Shannon was asked, basically as late as possible, if he could sit on his panel, and he gratefully obliged. So to that, we're thankful, Shannon. Thank you. Forfeiture proceedings are simple enough to understand in the abstract. An individual commits a crime. During the commission of this crime, they either use or come into the possession of an item of property, either real or intangible. The crime is discovered, and amongst other punishments, they are deprived of that property. The state gains possession, and they are able to dispose of it in the manner best suited to the agencies that actually made that seizure. Now, as with most instances in legal procedure where the rubber hits the road, it is rarely that simple. Would-be defendants may flee, leaving property unattended and having to be dealt with regardless. Remediable errors in criminal procedure may happen, and that might actually cost the state its jurisdiction over a criminal enterprise. Police and prosecutors are then left with property, maybe even contraband, and they have to dispose of it regardless. So in such cases, the property itself is what becomes the target of the procedural action, not the human perpetrator. These proceedings are colloquially deemed civil asset forfeiture, the state taking ownership of the property without an attending criminal conviction. It is the legal provisions that empower this that are, to some critics, what create the perverse incentive structure that some have deemed policing for profit, one in which prosecutorial and police discretionary decisions are made more in line with what might materially come about than with the true instances of justice. But again, with that, would that it were that simple. The first instances of property forfeiture, if we look back through the history of law, is when property was forfeited back in Roman law under the concept of nocturnal surrender. The concept of nocturnal surrender simply is where an item of an individual's property has harmed the property of another. This was, sadly to say, mostly to deal with offenses committed by slaves. And then that property and perhaps other property was actually used as remuneration. This evolved in the 11th century to the English law concept of deodans. Deodans are, simply put, an instrument that is ostensibly forfeited unto God, though in practice forfeited to the king, because of its intrinsic evil, its intrinsic complicity in an evil act. To wit, people don't kill people, demonic swords kill people, and then the king actually gets the forfeit. Contrast this with attainder forfeitures, which were the historical analogs of criminal forfeiture, where a felon's property, both real and personal, was divvied up between their direct lord and their king as punishment for his crimes and remuneration to the violation of the king's peace. This unilateral seizure of property became less prevalent in the wake of the Enlightenment and the social, cultural, and legal changes that brought about. Robust protections emerged in common law that were also codified in the statute. Like most provisions found in the Bill of Rights, here the Fifth Amendment actually was a direct response to the abuses of due process and takings that came from the Crown. Protection aside, the framers of the Constitution did not think it appropriate to actually forbid forfeiture entirely, and perhaps rightfully so. In a fledgling nation both deep in debt internally and externally, the only way to keep the government afloat was to tax a small diffuse tax base, or to supplement that with fees, tariffs, and property seizures from smugglers hoping to avoid these duties. Now, the wholesale adoption of in rem, that is, against property forfeitures, were pivotal in keeping the Republic afloat, and they aggrieved, at worst, foreign nationals seeking to circumvent U.S. law. Now let's fast forward today. Forfeiture, on behalf of the government, is practically ubiquitous at every level. Nationally, the use of equitable sharing agreements to split up forfeited property has increased at a rate outpacing inflation since it was codified, despite the long-standing drop in crime rates. In fiscal year 2012 alone, regional and local law enforcement entities in Texas reported closing the year with over $143 million in their forfeiture accounts. This is not part of any sort of budgeting process. To be clear, this number also includes forfeitures made pursuant to criminal forfeitures. Forfeitures made pursuant to a criminal conviction. However, to actually tell the difference between the two under current law is nearly impossible. To paraphrase Don Willett, Justice of the Texas Supreme Court, in his biting dissent in LLE versus Texas, this was the adjunct case to State of Texas versus 2004 Chevy Silverado. To paraphrase, the prevalence, procedures, and profitability compel us to re-examine the constitutional protections due to innocent property owners. This practice is what we actually chronicle in our report, Taking Contraband Without Taking Our Liberties, Civil Asset Forfeiture Reform in Texas. This is available online at texaspolicy.com, or it's also available in the back of the room if you'd like to take one before you leave. So to discuss this tricky topic, we've assembled a panel of top echelon stakeholders, from law enforcement to legal theorists, and even a state representative, to discuss the lay of the land and to discuss what reforms that we have coming in the 84th legislature. Our first speaker is Andrew Kloster from the Heritage Foundation, legal fellow in the Edwin Meese III Center for Legal and Judicial Studies. He focuses on civil rights, the role of the federal courts, and other constitutional issues. Before joining Heritage in 2013, Kloster was the Justice Robert H. Jackson Legal Fellow at the Philadelphia Foundation for Individual Rights and Education, or FIRE as we know. There he defended First Amendment due process rights of college students and professors. He has also worked on Capitol Hill and with a human rights organization under the United Nations. Andrew?
Thanks a lot, Eric. First of all, I'd just like to say thank you to TVPF. Heritage works with them on a number of criminal justice issues, and they do really innovative work, not just in Texas, but across the border in the United States. So I really appreciate the work that you guys do. And also thanks to IJ. They're constantly litigating these issues and working really hard to defend individual property owners. So I'd just like to start with that. Also, I would like to point out you have one of the papers that we put out at Heritage, just came out a few days ago, on civil asset forfeiture reform in DC, and some examples. You'll probably hear a lot of this from Matt. What are different types of reform that you can do, ranging from the extremely limited to the more robust reforms and kind of the benefits and harms that those reforms may have. So, okay, civil asset forfeiture. On a panel on civil asset forfeiture, it's a little bit tough to be the first panelist because, the name alone is just ridiculous. In government, you name, oftentimes lawmakers will intentionally or unintentionally give things a name that is sort of so bureaucratic and opaque that nobody's interested in it, but this is just a hugely important issue, so let me give you some examples. The core example of forfeiture, of what it was designed to seize, was contraband. contraband, drug paraphernalia, or a giant wad of cash that was sitting on top of a bag of drugs that the police happen upon. Nobody's going to claim the property, so it's not going to be a criminal, there's not going to be a criminal prosecution, but the property's still out there and they wanted to seize it. Or maybe you have a house that was purchased with drug money, or a house where drug deals take place on a routine basis. And all of this makes some sense, although folks may disagree with that. But it was these core cases that were the impetus behind forfeiture being ramped up really in the 1980s. And these are the cases that my former boss, Edmonds, talks about as, you know, when he was the 75th Attorney General of the US, he says, gosh, this is why we were told that we needed to improve civil asset forfeiture. Okay, but nowadays we have numerous examples of police using civil asset forfeiture, not to go after these types of issues or cases, but as a revenue raiser. And I'm sure that Matt Miller from IJ can give some horror stories of clients that he's had or his organization has had. But I'll simply point you to 3 resources that you can take a look at if you want a really popular 30,000-foot view of these issues. The first is the New Yorker article, which I think was a watershed. The New Yorker article taken by Sarah Stillman, and that came out in August of last year. And she gave the example of a case, an ACLU case in Tenaha, Texas, 8 miles from the Louisiana border, where local police pulled over the Henderson family, for example, for driving in the left lane without passing for some period of time. Now, there are factual disputes about whether that was the case, but they pulled them over and said, you know, you're driving in the passing lane, do you have any cash? And they took $6,000 of cash from this family, and then threatened to call the equivalent of DCFS and take the couple's children who were driving with them unless they willingly signed over the cash. So this was in a New Yorker article. This is a case that you can find, and there was an ACLU case against it. The second resource I'll point you to is the Washington Post series of articles that began earlier this year, which highlight numerous stories, such as that of the IJ client Terry Dicko in Michigan, and his small business. He was a grocer. He was an immigrant. He had a small business, and basically his insurance said, we're not going to cover any cash losses over $10,000. Okay, that's reasonable, that's insurance. So what does he do? Like any normal person with an insurance policy, he says, if I ever get $9,999 of cash, I'm going to deposit it to the bank because I don't want to have any more on hand, because then I will not be able to have my insurance cover those losses. So he does this time and time again. Next thing you know, the IRS has seized $35,000 in his operating account, saying, gosh, it looks like they're trying to evade our reporting requirements, because the IRS has a rule, which is if you make a $10,000 cash deposit, that needs to be reported to the IRS. And if you do it in such a way that it looks like you're evading these requirements, you know, that's something called structuring, that's a federal offense, and they seize this cash. So you ended up getting the money back thanks to pro bono representation, but I mean, when you have all of your money seized, you really can't hire a lawyer, and that's a huge problem. So the first to take a look at is the New Yorker article taken. The second is the Washington Post series of articles. And the third that I would point you out to is the third thing is the John Oliver segment, which you may have seen. He has a show last week tonight. It's a kind of comedic, sort of Daily Show-esque sort of show, but he's been doing very good work. And he recently, and you can find it on YouTube, he recently did a video on civil asset forfeiture and involving Texas and some sort of forthright legislators and Margarita machine. Okay, so those are some of the examples of abuse, and I'll leave it to Matt perhaps to highlight some of the more, take a more structured account, maybe some of the problems. There are due process problems, property rights issues, and federalism issues, because oftentimes the feds say, hey, you've got state laws against use of funds in a certain way, but we're going to give you cash directly using federal law, and we can avoid state law issues. So your state legislators, you have the power of the purse over your local law enforcement, but the feds in this area are often coming in to try to do an end run around state reform. So why has not reform occurred? If it's so easy, why are we even having a panel on this subject in 2014? Well, I would point out that sometimes there are law enforcement lobbies, for lack of a better word, and I work at a conservative organization that is very sensitive and very concerned with law and order issues. But I think the major lobby against this right now is the law enforcement community. That's not to criticize them. I think they may not understand some of the incentives here, and it may be in their benefit to actually have reform. So that's what I'm going to talk about. Let me skip since I don't have too incredibly much time. So why is this potentially a good thing for law enforcement to have forfeiture reform? First, I would just explain that ordinary budget appropriations is the carrot. If you're a state legislator, one of the things you can say is, if we're going to have forfeiture reform, you, local law enforcement, come in and tell me how much money you're going to have as a shortfall. And we can consider, if we turn this forfeiture, the forfeiture funds go back to the general fund, and then we can have a conversation about how much money you actually need, for example. This is the conversation that occurred in DC, where forfeiture reform was passed recently. And that's potentially a tough hurdle, but I think ordinary budget funding law enforcement is incredibly important, and requiring them to hunt for their own funding is difficult. And while there are prohibitions usually on using forfeiture funds for personnel, so that people don't think like their job depends on this, there's still incredible pressures on them. So I would just say, number one, it's very important to adequately fund law enforcement so that they don't need to use civil forfeiture. And so if the carrot can be ordinary budget appropriations as a quid pro quo, to some extent, to grease the wheels here. The stick is victim stories. And in Texas, you've got a lot. Tenaha, Texas is one good example. I'm sure you've got numerous examples of border crossings where oftentimes law enforcement is not interested in northbound drugs, they're interested in the southbound cash. So, hey, go ahead and sell. We're not going to actually, we don't care about these sorts of things, or it's hard and we're not going to get, the money out of it, but we'll try to seize the cash going down. That's a bit of a problem as well. So the carrot is ordinary budget appropriations. The stick can be victim stories because they're out there. The classic case is a college grad. He graduates from college in like New Jersey, let's say. His dad gives him cash. He says, he wants to make it as an actor in California. He drives across country and he gets stopped somewhere in, say, Oklahoma or North Texas, and they end up seizing his cash. That happens all the time, and these folks are very easy to find. It should not be difficult for you to find examples of forfeiture abuse in or around your communities. I guess let me just talk then briefly, I've got about a minute left, about federal reform. It will come up next year. Senator Rand Paul, for example, has introduced a bill where he wanted to remove the equitable sharing incentive entirely. There were some members in the House that had bills that went further with some procedural reform. I guess I'll leave it with that. Just point out that, we've got one. Right, so we've got bills on the House side, bills on the Senate side, and it's going to come up this year. Why is that? Because, I can be on a panel here as a representative from a conservative organization with, folks on the left and, libertarian organizations. People understand this. It's a really easy kind of an issue. There's no lobby, unfortunately, or fortunately, there's no lobby in favor of forfeiture reform because no one stands to make any money off of it, but there's a lobby against it. But things are moving. It's in the popular culture now, and again, just to repeat, the New Yorker article is great. It's called Taken. The Washington Post series of articles is an excellent resource, and the John Oliver segment, you can find it on YouTube. Those are all three things that I would encourage you to take a look at to learn a bit more about this issue. Thanks.
Thank you, Andrew. I have to say that's probably the first time John Oliver was cited at one of our policy panels. I'll be sure to send a thank you card out. Moving on with the panel, Matt Miller from the Institute for Justice is the managing attorney of their Texas office, where he fights to secure property rights, economic liberty, freedom of speech, and school choice. Matt represents individuals and small business owners in federal and state courts in Texas and in and around the country. Matt successfully defended the author and publisher of a book about eminent domain abuse after they were sued for defamation by a powerful developer, and successfully litigated against the city of El Paso, Texas, to force the city to repeal a law that prohibited street vendors from operating near brick and mortar restaurants. His litigation also won legislative repeal of a law requiring computer repair technicians to obtain a private investigator's license. Can you only imagine that here in Austin, if we had something where the food trucks were not able to be near restaurants? I think that'd be almost an untenable business model. But without further ado, Matt Miller from the Institute for Justice, Texas.
Thank you very much, Derek, and thank you all for coming out for this. I think that Andrew did a very nice job laying the groundwork for this issue. And so I just wanted to touch on a few themes that I want you to take away from this policy primer. And those themes are: forfeiture is big, it is a problem, and there is something that you can do about it. I'm not going to go over the numbers again because Derek told you the numbers. They're large, and we're talking hundreds of millions of dollars. Forfeiture is big in Texas, it's big around the country. And I don't think I need to convince you all any more of that. But let's talk about why forfeiture is a problem. It's a problem both for property owners and for, I think, law enforcement officers. This is something that Andrew touched on. But let's talk first about property owners. You've all heard the horror stories, and they're real. What happened to the Decos with their business and the structuring case. What happened in Tenaha. There are true kind of shocking horror stories about forfeiture in Texas and all around the country. But as important as the horror stories are, the everyday machinations of forfeiture are what I wanted to kind of drill down on a little bit. And let me paint a picture for you. Back in 2010, my colleague Scott Bullock and I were in the courtroom in Harris County, Texas. And in Harris County, one poor judge is assigned the forfeiture docket for some period of time. So that judge, a couple days a week, gets to hear nothing but forfeiture cases. And in this courtroom, the prosecutor is camped out and has a quasi-law office on one side of the courtroom. So there are just boxes of forfeiture cases. And the prosecutor and her assistants are camped out there, and they'll be bringing case after case after case in front of the judge as he or she hears the forfeiture docket. There's no one on the other side of the courtroom representing property owners. And when you hear these cases being called, these are not drug kingpins. These are State of Texas versus $823. State of Texas versus one 1989 Ford or Dodge Caravan. In Minnesota, I don't have the number for Texas, but in Minnesota, the average civil forfeiture was $1,200. So yes, civil forfeiture is a useful tool for fighting drug kingpins and major criminals. But more and more, it's used to take small amounts of property from ordinary Texans. And the reason there was no one on the other side of the courtroom is it's not worth it to go to court to try to get that property back. You're not going to pay an attorney $3,000 to get $1,200 worth of property back. So in many cases, I don't know if anyone's gotten a speeding ticket lately, but you'll notice that police will often ask you if you have any cash on you when they pull you over. The reason is that they're looking to seize and forfeit that money. Obviously, speeding has nothing to do with cash, but you're required to answer the question truthfully if you answer it. And they will oftentimes take that cash and then seize it. That's why you get State of Texas versus $832. These are small amounts of money. And so the judge will call the case, the prosecutor will stand up to represent the state, and then the judge will ask, is the property owner here? And time after time, no, the property owner's not there. Is his attorney here? No, his attorney's not there. And so the judge enters a default judgment against the property owner. And you can see this in Harris County, you can go down and see it for yourself. I'm sure it's the same in courtrooms around the state. It's a petty problem, but it affects lots and lots of Texas property owners. And $1,000, an old Dodge Caravan, those are real assets and real property for these people. And it materially affects their lives when they're taken. They need these vehicles to drive their children to school. They need this money to buy groceries. And forfeiture gives police an incentive to take it without charging anyone with a crime. And that's an important point. We can reform criminal asset forfeiture while still leaving, we can reform civil asset forfeiture while still leaving criminal asset forfeiture as an available tool for law enforcement. If you bring charges and convict someone of a crime, you can take the fruits of that crime. Criminal forfeiture will still exist, but under civil forfeiture, you can take the property, never charge someone with a crime, and the burden is then on the owner to get that property back. So let's talk about why this might be a burden for law enforcement. Whenever we tell people about civil forfeiture and we try to explain it to people, one way in which people would push back is they would say, well, that's not actually going to skew law enforcement priorities because police are good people. And police are good people. And this isn't about police or prosecutors being bad people. But it's about incentives that incentivize good people to prioritize certain things, like civil forfeiture, instead of other things, like other law enforcement activities. So we worked with some professors who conducted a study. And it's an area called experimental economics, and it's actually a Nobel Prize winning area of economics, but it's hard to explain to people. It involves a series of games that people play, and you test different incentive structures within those games. And so we wanted to see, do incentives affect the behavior of ordinary people? And the answer is yes. The kinds of forfeiture incentives we have in Texas and around the country absolutely influence people's behaviors. And here's what the authors concluded. They said, the experiment's results suggest that the problem with civil forfeiture is not one of bad apples, but bad laws that encourage bad behavior. It is not the players, it is the game. When civil forfeiture puts people in a position to choose between benefiting themselves or the overall public, people choose themselves. And, you know, if we reformed civil forfeiture, we could allow police to put their efforts and to put their activities into pursuing law enforcement goals that we can all agree on, rather than pursuing civil forfeiture. And I imagine the burden on them would be much less. Because again, these aren't bad people. But if they have to fund 30% of their budget through civil forfeiture, they're going to pursue more civil forfeiture. And that takes time and police energy away from other activities that can be better spent protecting the public. So I hope you're convinced now that forfeiture is a problem. It's a problem for property owners, and I think it's a problem for police and prosecutors. Let's talk about what we can do here in Texas to address the problem. I've already said you could eliminate civil forfeiture. You know, North Carolina doesn't have civil forfeiture, and yet police and prosecutors are able to operate there without a problem. Minnesota just passed a law requiring a conviction for forfeiture. Now, it's still technically civil forfeiture, but someone has to be convicted of a crime. So you've essentially eliminated civil forfeiture in Minnesota. Texas could do the same thing, but short of that, there are 4 things. You could eliminate policing for profit. Require police and prosecutors to take that money and put it into some kind of general fund, where you then have a legislator or a city council or county commissioners who are deciding how that money gets allocated. They're not self-funding anymore. The money goes into the general fund, and then the individual elected representatives decide how that money is going to be spent. Second, you could provide greater protection for innocent owners. And in the forfeiture context, innocent owner is a technical term. I would argue that a lot of the people who get their money or cars taken and aren't charged with a crime are innocent. In fact, if they're not charged with a crime, I think we can presume they're innocent. But something else happens where, you know, someone loans their car to their son, and their son is out dealing drugs out of the car. And then the police bust the son for dealing drugs. The son is actually convicted, but the police and prosecutors take the car, and then it is the owner's burden to prove that they didn't know that the car was being used in conjunction with illegal activity. That's backwards. It should be the government's burden to show that the owner knew or should have known that the car was being used in conjunction with illegal activity. It's very hard to prove a negative, and it's also expensive. And these innocent owners who have their cars taken or have their houses taken have to pay for their own lawyers. And then they have the burden of showing that they're innocent. That's a due process problem, and we can address it by shifting the burden through a change in the law. Third, I think we need better reporting. We have reporting in Texas, and it's C+, B-. You know, as far as a high-level overview, I think it gives you big numbers. That's the numbers that Derek was quoting. But what we don't know, and what we should know, is how forfeiture is actually being used on the ground. Forfeiture is an awesome power. It's the power to take someone's property and make them get it back. If we're going to allow police and prosecutors to use this power, we need to know how it's being used. So let's know exactly what's being taken. Let's know how many default judgments there are. Let's know whether or not the property owner hired an attorney. Let's know where the money is going and how it's being used. This wouldn't be that hard to report. And like I said, if you're going to give someone this power, they should be accountable for it, and we can make them accountable for it through increased and enhanced reporting. And finally, and Andrew touched on this, there's the problem of equitable sharing. So no matter what Texas does, no matter how much we reform our state laws, local law enforcement can circumvent those laws by teaming up with the federal government, and then they split civil forfeiture money, 80%, 20%. 80% goes to local law enforcement, 20% goes to the federal government. Texas can limit equitable sharing or eliminate equitable sharing, but something I might propose is a floor for equitable sharing. Some U.S. attorneys' offices have this. They won't do equitable sharing cases that are below $25,000, that are below $50,000. So you can still use equitable sharing for the drug kingpins and the big cases, but it eliminates the penny ante stuff, the stuff that I saw back in the courtroom in Harris County, and it allows Texas reforms to actually have some bite. And I think that, you know, as a state that values our independence from the federal government, we should be pursuing that, because if we reform civil forfeiture, which I hope we will, we want those laws to be effective to protect the property owners of this state. I'll take questions once we get to the Q&A Thank you.
Thank you, Matt. Shannon Edmonds is the Director of Governmental Relations for the Texas District and County Attorneys Association, or TDCAA, the largest statewide association of prosecutors in the nation. Mr. Edmonds served as a liaison between prosecutors and the Texas legislature on issues of criminal justice, juvenile justice, and governmental representation issues. Upon conclusion of each session, he authors the TDCA Legislative Update book. I can speak from personal experience that book is incredibly consumable by a lay audience, and everybody in the policy community appreciates the work that Shannon does on that. Mr. Edmonds also provides training, education, and assistance to members of TDCAA and other legal and law enforcement entities. He's also written many articles and given many presentations on the legislative process and other varieties of legal topics, including capital punishment, prosecutorial ethics, DUI law, child abuse, gambling, and mental health issues. So without further ado, Shannon Edmonds, Texas District and County Attorney.
Thank you, Derek. Thanks to TPPF for having me. I'm glad I could fill in on short notice. I know our prayers are with Chief McLaughlin's family. I kind of was sitting there thinking, gee, Mrs. Lincoln, other than that, how was the play? I mean, yeah, let's end this right now. It sounds horrible. Of course, there is another side of civil asset forfeiture. And I want to go back to a phrase that some who've come to the policy primer that TPPF does every January have heard me use in the topic of overcriminalization, which is it's called the fence rule. Something that G.K. Chesterton, a great thinker, came up with. He said, before you take it down a fence, you need to sit down and figure out why it was put up. And then, if you can figure out that that need is no longer there, take down the fence. So why was civil asset forfeiture created? Well, it was created in Texas in 1989. If you know your history, you know that 1989 was close to or the peak of crime, high crime in Texas. Compared to today, crime was 120% higher, the crime rate in Texas. We have cut crime by more than half in the last 25 years. Of course, now when I normally say that in front of a law enforcement group, that's an applause line, right? But in this building, it's what have you done for us lately? All right, it's hey, great, we're glad that you guys cut murders by 3 times and you've reduced property crime, but we're working on this budget. What have you done for us lately? But it's important to know that history. And the reason why civil asset forfeiture was created was because it was ridiculous that people would get criminally convicted of crimes and then law enforcement would have to give their property back to them because there was no mechanism for keeping them from enjoying the fruits of their ill-gotten labor. Crime shouldn't pay. We all know that. We learned that in elementary school. And that's what civil asset forfeiture is about. It's making sure that crime doesn't pay. So there are 2 aspects of it. It's not just what is done with it and whether it is used or misused, but it is taking those proceeds and those criminal instruments away from the bad guys. And I submit that civil asset forfeiture has been very, very successful in that regard over the course of its lifetime. So why are we reevaluating it now? Well, as I said, crime rate is at a 40-year low. You have to go back, at least in Texas, when we have 10 million more people in Texas than we did in 1984, but we have the same number of crimes. Okay, think about it, 10 million more people, the same number of crimes. What that means is that crime is not important to voters anymore. You look at a poll of the issues that are most important to voters, crime and drugs pulls in about 3% of voters say that's the most important issue today. Immigration, border security, the economy, jobs, healthcare, all those things rank above criminal justice in the voters' minds. Now, we've looked at polling, if you go back 20 years to 1994, the number of voters who said crime and drugs was the most important issue was 52%. So that just shows you how things have changed in the mentality of what's important to voters and what's important in this building. The other thing, the second thing that has generated some more interest in this, I think, is the rise of libertarianism on the right, which has been a big sea change. You know, it used to be a pretty easy dichotomy in this building. You had on the left, you had the hug-a-thuggers, and on the right, you had the tough on crime, lock them up and throw away the key. And now you have a blending of the two, meeting in the minds of folks who are libertarian. We're seeing an increase in that presence in Republican elections, okay? And one of the things that goes with that is not just that government should do a few things and do them well, but that government should stop doing things, stop taking my money, and that we need to shrink government, right? What was Grover Norquist's famous saying? I don't want to abolish government, I just want to make it small enough so that I can drag it in the bathroom and drown it in the bathtub. And I mean, that's a great synopsis, you know, tongue-in-cheek, but it seems like we have this mentality that any revenue generated by the government is bad, because you can't shrink government if it has a source of revenue. We're seeing this some, I think, with the lottery debates. Long we've had opposition to lottery from social perspectives. You know, the Baptist General Convention has been against it for a long time. Now we're seeing people who just think that government shouldn't have revenue, and so we need to get rid of it, because we can't shrink something that has these outside sources of revenue. And that's something that's hard for law enforcement to understand, because they keep thinking, come on, I mean, Republicans are law and order, right? It's like, well, you gotta understand, you are the government. If you wear a badge or you are a prosecutor, you are the government, and there is too much of you in the theory of many folks in this state and in politics now. So the second thing that has contributed to this rise in a debate about asset forfeiture is just the general distrust and desire to limit what government does. And then the third thing, of course, is always money. Money, money, money. Money always drives the train in this building. The same thing happens in your local commissioners' courts. I get tickled when I hear folks say, well, just give up asset forfeiture and then come to the Capitol and ask for that money. Because I can tell you, there isn't a single Republican who's going to be in the next legislature who won his primary saying he was going to spend more money. Not a one. Right? They came to cut. So it's really sort of disingenuous to say that that is a better option for law enforcement. And remember, prosecutors and law enforcement get almost no funding from the state government. Because there is reporting, we know that there's about, $142 million held by all the local law enforcement and prosecutors in the state. And that split is usually about 70 or 80% law enforcement, 20 or 30% prosecutors. I just looked up the budget of the Harris County Sheriff's Office. Their annual budget is $392 million. So all the law enforcement agencies in this entire state have less in their asset forfeiture funds than one sheriff's office. So, you know, is it big? Well, it's all relative. But it is a problem when people abuse it. And that's something that I think Texas doesn't get enough credit for addressing. All right? This statute was created in 1989. I looked. It has been amended every session since then. Every session since 1989, that chapter has been touched. And in most cases, it's to expand it. Now, recently we've seen some attempts to limit it as well. And those have come from some of the horror stories that you've seen. And I give credit to Senator John Whitmire in the Senate. This has been an issue that's been very interesting to him, and he's taken the lead in making sure that some of those abuses are limited. And so when we hear things about margarita machine, I mean, you know, they made fun of that really funny video in that John Oliver thing. It's a great kicker at the end. You definitely need to watch it. But that happened 10 or 11 years ago, you know? And the DA lost his election. He finished third in the three-person race because of it. So we just had a DA up in Dallas who just was the darling of the media. He just lost his election in part because there are questions about how he was using his asset forfeiture money. And that's how it should be. There is an answer at the ballot box. And we also know that some of the reforms and oversight that have been put in place over the past 10 years by Senator Whitmire and others are working, right? The process is working in Dallas. So they're going to make sure that they get to the bottom of that. And what we're not seeing any of is what good comes out of it. Because government working properly is not news. It's not. It doesn't make for good clips. It doesn't make for funny John Oliver skits or something on the Daily Show. It's boring. And frankly, I'd be happy if asset forfeiture became nice and boring. All right? Prosecutors have worked with Senator Whitmire and others in the Capitol to make sure that asset forfeiture is used properly. And, you know, I know Derek started off with quoting Roman law. I'm going to throw some Latin at you that came to my head. All right, although it's from St. Thomas Aquinas. Abusus non tollit usum. Misuse of something does not render it useless. Just because somebody abuses something doesn't mean it's bad. It just means that you need to address the abuses of it. And that's something that Texas has done very well lately. And so, you know, I get interested when you know, there's always two ways to see things. Matt's down there talking about this court system in the civil court where the Harris County DA's office is hearing all these cases. What I think is, man, that is a hell of a lot of due process we're doing for $800, right? The prosecutors have to file a claim within 30 days or they have to give it up. They have to give notice to the owners, or if it's a vehicle, they have to track down whose name is on it and make sure that they know that their vehicle was used in a crime or that it's the proceeds of crime. They have to try to get them to court. All those things are exactly what I think most people want to happen, but you don't hear that it's happening because that doesn't fit the narrative that advocates want. And so I'm happy to be here and answer some of the questions. Hopefully we can have a good discussion about that. Thank you.
Thank you, Shannon. Finally, Representative David Simpson is the state representative for House District 7, comprised of Gregg and Upshur counties. Since winning his first state election in 2010, Representative Simpson has served on the County Affairs, Land and Resource Management, and Joint Coastal Barrier Systems Committees. Prior to his service in District 7, Representative Simpson served several terms as the mayor of Abinger, Texas. In the private sector, he is the president and chief executive officer of Abinger Timber, LLC. Representative Simpson has a bachelor's degree in philosophy from Vanderbilt and is a graduate of the Trinity Ministerial Academy. Without any further ado, Representative David Simpson.
Thank you for this opportunity. I had anticipated coming here really to listen and to learn, and I was asked to come and of late to speak about it, and I'm very glad to welcome a large delegation from my own district, District 7, Upshur and Gregg counties, our sheriffs and law enforcement and county judges, and police chief and assistant. Thank you all for being here. Like many government ideas gone awry, the thought behind civil asset forfeitures may have had a kernel of sense in it when it was first conceived. The force of government should only be employed when one individual harms a neighbor. Then it is right that government forces restitution to the neighbor or to the public. And such restitution should include ill-gotten gains. Furthermore, it may be prudent for civil authorities to preclude the use of some property connected with criminal activity until conviction and sentencing has occurred. So there may be, and indeed be, a place for temporary or permanent forfeiture of property in the pursuit of justice. While our Constitution never contemplates injustice as a means to achieve justice, civil forfeiture laws have been codified and enforced unjustly. Knowing that the propensity of government is to overstep its bounds, the Bill of Rights was added to the Constitution to ensure its ratification and to prevent abuse of the powers that were granted. The Fourth Amendment provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue except upon probable cause supported by oath or affirmation and particularly describing the place to be searched and the persons or things to be seized. The Fifth Amendment provides, among other things, that no person shall be compelled in any criminal case to be a witness against himself, nor deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. Even a cursory reading of those provisions would inform an individual that the concept of forfeiture of assets should at a minimum require a warrant and due process before the government could take an individual's property. But that isn't what is happening. By now, many have heard about instances like those here in Texas where police targeted minorities driving in rental vehicles for traffic stops and then confiscated large amounts of cash through coercive means. In such instances, criminal charges were not filed and the individual was intimidated into signing over rights of property to avoid what they considered bogus charges being filed, or in one case to avoid having children taken and put into foster care. That's modern day highway robbery with a twist, where the white hat holds up the coach and empties the pockets of the travelers, acting as judge and jury. How can they do that, you ask? Well, to get around those pesky little constitutional issues, legislatures, both state and federal, have created a dual system of justice, whereby the assets of an individual are named in a case, as we've heard, not the individual themselves. We have established laws in Texas and the United States where the owner of property is presumed guilty until they can prove their own property was obtained through legitimate means. The state has now a low threshold to show that property may have been used in illegal activity. The very presence of cash can be assumed to be a result of drug activity. We should not be proud of these means that effectively nullify, mute, or cripple constitutional restrictions on government power. In some states with higher standards of forfeiture than federal requirements, local and state authorities are now working with federal officials to seize assets and share the proceeds on an 80-20 basis with the initiating agency. In other words, law enforcement agencies are working in conjunction with the federal government to intentionally circumvent state law. Allowing participation in such situations is nothing less than selling our citizens to the federal government. If we expect a society of law and order, we must craft our laws to ensure justice is achieved justly. We cannot allow government to steal from citizens and then condemn the citizens for doing the same activity. The taking of assets from a citizen should not be easier than the conviction of a crime. Reforms in the area of civil forfeiture should include: citizens and their property should have a presumption of innocence. The burden of proving that property was the result of ill-gotten gain should be on the government, not the accused. And it should have the same standard as a criminal case. The way it is now, the owner of property has to prove, and many times, a negative. Also, we should check improper motives. Proceeds from seized assets should be directed to crime victims or indigent defense rather than to fund law enforcement. Law enforcement should not fund itself. It should be funded through the budgetary process. Furthermore, the government should not retain property unless there is first an indictment and second a conviction for serious crime. Moreover, there should be appropriate requirements of timeliness to ensure this provision is not abused. Property should be returned in good condition, and law enforcement should not have immunity for damage that results in financial injury to an innocent owner. We have a constitution of liberty and limited government. They stand or fall together. Liberty used irresponsibly produces more government. But a government that uses force unnecessarily or unreasonably not only reduces individual liberty, but it invites anarchy. It is not good government. In East Texas, we have a saying, fences keep the honest people out. Our Constitution is a fence that we need to keep and maintain good government. Thank you, and I welcome an opportunity to discuss this with you further, especially from my own delegation.
Thank you, sir. So now we begin our question and answer period. If you'd like to approach the microphone right over here on the other side of the post, we will get to as many people as possible. But just to kick it off, I'd like to take the moderator's prerogative and direct a question at Matt and Andrew. Why, and you both highlighted this in your remarks, why is federal reform important part and parcel with state reform?
Sure, yeah. Well, is this on? Can you hear me?
Yes, it is.
Okay, great. So I think the main reason that federal reform is important is due to the fact that the feds account for a large proportion of these seizures, and because state and local law enforcement, when hampered by procedural rights and reforms at the state level, often will say, hey, to the feds, we've got this great case, and then launder the money more or less through the feds, and the feds give them the kickback of 80%. Now, there's a reason for equitable sharing. There's a place for it, I think, in certain circumstances, but it's certainly now being abused. But if I could just, one thing that I wanted to point out was the point about libertarianism on the right, and is this just a libertarian moment? Is that what we're seeing? My organization is quite conservative, and yet, and let me also talk about reform. Reform in 2000 was sponsored, was spearheaded by Representative Henry Hyde, my former rep, who was no, wilting lily. He also, you've heard of the Hyde Amendment, the prohibition on use of federal funds for abortion, and him as well. Extremely socially conservative, extremely law and order, and he was the guy that was in favor of federal reform back in 2000. So I don't think that it's a libertarian thing. I think it's a good government, good practices sort of a thing, and we'll just leave it at that.
Anyone else? Okay, well, since we have questions queued up, let's go to the forum.
Yeah, my question, local law enforcement agencies, they receive sometimes revenue from state agencies in the form of equipment grants or other things, or even from the federal government. If in deciding those grants, should they be looking at how much money the local law enforcement is getting from civil asset forfeiture, and kind of saying, if you're getting revenue sources from seizing all this money, maybe you don't need as much grant money to cover your expenses?
My concern with that is that it would increase the use of civil forfeiture instead of decrease it, because then you would wind up with a shortfall. So my initial read on it, and I haven't studied it, my initial read on it is that that could create more problems than it might solve.
Certainly. That was a great question on, yes, Shannon.
You're way too tall for me to show. I apologize. The other problem with forfeiture is it's difficult to budget for. It's not a ready revenue stream like it is from your commissioner's quarter from the state. So if an agency is relying on seizures off of a local interstate, those could vary greatly depending on what path through the country the drug gangs decide to use, and as they switch from one route to the other, forfeitures can go up and down, so it's very difficult for law enforcement agencies to use it as a budgeting tool as well. But it's certainly something that you can take into consideration in grant funding just in general, but it's very difficult to project forward what that's going to be.
I think that points out one reason why it's important to have general budget processes for law enforcement, precisely because it's hard for them to rely on this. Although, interesting point, many do. DC, for example, has budgeted tens of millions of dollars in forfeiture funding, which federal regs say don't do that, but they do it anyway.
I think it's dangerous anytime that we chase federal dollars. When we do so, we often lose our independence. And I think it's important that we never sacrifice principles for dollars. On the other hand, I just want to say that I think forfeiture, when you have assets to pay for a crime, is part of justice and should be done. I support criminal forfeiture based on the conviction, being charged and convicted of a crime. That's important, and that is what justice is. If you've obtained the gains through criminal activity, those gains should be restored to those who they didn't take it from. And if we can't track them, it should go to the public, and it should pay for the system of justice. So I have no problem with forfeiture when it's used with due process.
Well, Derek, I feel compelled to answer a question about grants. Currently, I'm the head of the Criminal Justice Division of the Governor's Office, and we do criminal justice grants. And one of the things that we've been struggling with over my tenure there has been the question of civil forfeiture. What kind of money do some of these jurisdictions have? And we do ask jurisdictions to provide us with the information as to what they have in the forfeiture accounts. It's been hard getting to this point, but I think it's getting better. So that kind of leads to my main question, I guess probably directed mainly towards Shannon, would your organization, or do you think the law enforcement community would be against at least having the forfeiture money that comes in at the state level go into GR, so we could precisely avoid some of these budget questions?
Thanks for asking. That is not something that has been discussed among our group. My gut feeling is that they would not be in favor of that. Mainly because I had to ask. Part of the experience, if you're in the criminal justice system, is the state constantly taking money out of the criminal justice system, charging fees, fines, court costs, and things like that the state uses to fund non-criminal justice issues. It's very frustrating to everybody in the system, prosecutors, defense lawyers, and other folks. And so their experience dealing with the legislature is that usually the money goes one way, the wrong way, between local courts and state government. And I also always get kind of tickled when you have this cognitive dissonance between folks who are local government, or limited government, local control. Oh, but let's send it all to Austin. That doesn't compute to me. I think the folks locally are in the best position to decide what their needs are and what that money should be spent with. And the other thing you need to know right now is that prosecutors and law enforcement and commissioners and city councils argue all the time over what that money is, because your commissioners and city council members want to get that money and use it for non-criminal justice purposes. And that's very frustrating to law enforcement, who aren't being adequately funded to begin with. So that's kind of how we've ended up in this situation right now. But no, to answer your question, I'm guessing that wouldn't be that possible.
Mr. Edmonds, during your talk, I think we all agree that crime shouldn't pay. You're going to have a hard time anywhere agreeing with you on that. And what seems to follow from that then is that criminal forfeiture, where someone has been convicted of a crime, should follow, and thus we should be able to take their money. And so, would you support the elimination of civil asset forfeiture and only allow for criminal forfeiture? And if not, I guess I'm wondering, you said abuses do exist, and I work at the Institute for Justice. We have no problem finding victims of civil forfeiture or abuse. So if these abuses exist, we're in a state legislature. I'm wondering what reforms you actually do support.
Sure. Well, and I'll tell you that I'm here, at the last minute. and I work at TDCA, but our association will not take a position on this. We have 330 elected prosecutors, and our job is to tell them what's going on here at the Capitol, and let those elected officials get involved in the legislative process and decide what they want to support or oppose. And, you know, on something like marijuana, man, our folks are gonna be all over the map on that this session. You know, that's another new phenomenon that we're gonna see. So I just give that as a little disclaimer to begin with. One of the questions I have, because we don't have criminal asset forfeiture here that requires a conviction already, is the timing of this. You know, Mr. Miller talked about seeing this civil process go on, because it is property, right? We're not convicting a person, we're trying to decide what to do with the property involved in that crime. And in order to get it back quickly to the right people, if the state shouldn't have it, we have accelerated timeline. So the state has to decide within 30 days whether or not to file a forfeiture lawsuit or not. Now keep in mind, these are felony cases, and in a felony, the state can take up to 6 months to indict a case already. So in these states where they have switched to a conviction-only situation, what happens to the property when it may take 2 years before there is a conviction in the case? It seems to me like having a more expedited civil system, where, by the way, the state does have the burden initially to show that this, by probable cause, the same standard as getting an indictment in a criminal case, that the property, that a crime was committed and that the property was connected to that crime. So I'm curious how these other states process it, because the real reality is most of these default cases are because either no one is claiming the property, or because they're guilty and they don't want to come and say, yeah, that's mine, because then that will make the criminal case easier. So that's the reason for most default judgments in these cases. It's not that people are being railroaded, it's that oftentimes nobody comes to claim it, but we have instituted, and we should institute, due process to make sure the government isn't just picking up abandoned property and keeping it.
Do you support any reform?
Our association will not come out with anything like that. You'd have to talk to individual prosecutors to decide what they would or won't support.
I'm not entirely confident that most civil forfeitures are the result of abandonment or of someone being afraid because they think that they'll be indicted, so another type of abandonment. So I'm not sure that all abandonment, and that's something that folks can take a look at and ask local law enforcement for numbers, if they have any numbers on these sorts of things.
It's also a reason that we should have better reporting on what's going on, so we can verify the claims that I'm making and the claims that Shannon's making, and actually understand how forfeiture is working at a granular level in this state.
This is for Mr. Edmonds. You're a popular man. You spoke about the legislative process, and I understood you to say that every session since 1989 has in some way changed the statute, and that every time it's expanded the forfeiture scope, which would say that, well, everybody's happy with this, I guess. But you also mentioned that, well, if there are abuses, Senator Whitmire's done some great work with it. Could you speak to that sort of, there seems to be a tension between those statements. Could you speak to what you said about the legislative process more?
Yes, I can. You know, at the legislature, oftentimes the left hand doesn't know what the right hand is doing. And many of the changes to the statute have been relatively minor. You know, just adding some random finance code offense to the list of offenses for which forfeiture may apply. Because remember, it doesn't apply to all crimes. There's a list of offenses which can trigger asset forfeiture, but it's not even most crimes, it's just mostly certain felonies. What we have seen in reforms have been in response to specific horror stories that you've seen in the paper. So we have a statute now that basically says you can't spend forfeiture money for margarita machines. You can't spend asset forfeiture money on your own political campaign. You can't donate asset forfeiture funds to a charity or an entity unrelated to criminal justice. And each one of those came out of headlines or news stories where there was an abuse. right, in the Tenaha case, which is how long ago? Was that 6 years ago? Yes, that's 6 years ago, right? Murdering machine 10 years ago, Tenaha 6 years ago. We instituted some reforms that said officers can no longer do what Representative Simpson mentioned, which is at the side of the road, try to convince drivers or citizens that they should just waive their interest in that money. And a related issue is they said that you can't bring them into the police station and try to get them to sign a waiver. The state can't do anything for 30 days. You have to file that action and give the person notice so that they have time to decide what to do, whether or not they want to claim it, if it really is theirs, and not be subjected to that type of improper pressure. And so we've made reforms in 2009, 2011, last session. We instituted a list of things that you can spend it on, just to be clear, because law enforcement and prosecutors, they know that misspending money is one of the things that gets you unelected, okay? So they're often over-cautious in how they spend it, so they're frequently asking the Attorney General or asking our office how they can spend it. So we handily put a list of things that law enforcement and prosecutors know that they can spend the money on, like bulletproof vests or training or things like that I think everybody agrees is a legitimate use of that funds, and which by being used avoids the need to have to use tax dollars from ordinary citizens.
I'm going to make a quick follow-up question. You mentioned about the police stopping you and not being able to coerce the money out of you. But I heard the comment about the police asking, do you have any cash? I just stopped you for 35 or 30 zone. And the comment was made, I believe Mr. Kloster said this, you must answer truthfully. But he didn't say, must you answer? Are you required to answer that question?
I don't know if
It wasn't me, but I
require
think the
you.
answer would be no.
Yeah, I don't know if anything would require you to answer that question.
You can just not answer. Okay, thank you.
Thank you. Sir.
The discussion of the last 1 minute may have obviated most of what I was going to ask. I was going to remind everyone the subject was civil forfeiture, not criminal. And Mr. Miller and Mr. Kloster both gave good examples where there was no conviction, there was no criminal, there were no fruits of the crime. And Mr. Edmonds, you kept talking about, with your fence example in '89, it was the height of the crime rate. Nobody's talking about a crime in some of Mr. Miller's examples. Representative, you gave an excellent talk, mostly based on crime. There was discussion of probable cause, all those other criminal things. But I think if you look at some of Mr. Miller's examples, such as the one we just talked about, literally in the 1 minute, and I was already in line, of a policeman asking you how much money you have in your pocket. And Mr. Edmonds, I don't think for a minute, but feel free to correct me, that if you leave here today and head back to the office and a policeman stops you because your brake light is burned out and asks you if you have any money in your pocket and then says, why don't you come down to headquarters and sign a waiver, I don't think for a minute you would be anything but outraged. And I don't know any neighbors or friends who think that isn't far over the line. So I would recommend to the representatives in the room, if you take this up in the coming legislature, be sure everybody's hearing the difference between civil and criminal. Be sure everybody's hearing the everyday examples that Mr. Miller gave, and don't wad it up into this big ball of forfeiture, because a very large